Defense have a motion.
Yes, Your Honor. We would like to move for acquittal in this case because the state has not met their burden in terms of proving first-degree murder. Under the NEDA state codes, the standard for first-degree murder and second-degree murder requires the elements of deliberation and intent. These need to be shown beyond a reasonable doubt. However, we haven't heard from any witnesses that were able to hear the conversations, that were able to see the interaction between Officer Doyle, and there's no way that a juror could rationally conclude that there was deliberation and intent on behalf of Officer Diamond. Further, there's been no showing of a voluntary act under the NEDA statute principles of criminal culpability. A voluntary act would require the state to prove that the defendant acted consciously after effort and determination, and also that he was aware of his physical possession of the firearm. Now, while we, first of all, don't understand whether or not he, or we have not been shown that he acted consciously or with any effort or determination, we certainly don't know that he was aware of his physical possession or control of the weapon when the second shot was fired.
Who's testified otherwise? I mean, one thing we know, and you all apparently even agree, that when he left the police department that morning, he had the gun. There's no suggestion that she had the gun. And although you've given us a theory in your opening statement, that's evidence of nothing. That she apparently did some sort of a karate move and was able to get the gun out of his hand, and then the thing fired. So because we don't have any of that, what do we have that would show he wasn't in possession of the gun?
Well, the burden is on the prosecution here to show that the defendant acted guilty beyond a reasonable doubt.
Yeah, that's not a question. Because the point you were making is that he wasn't in physical possession of the gun at the time it was fired.
I apologize.
And what I guess I'm confused about is how we've established that he wasn't, because we have established that at some point prior to the gun being fired, he was.
Well, we're not arguing that he actually wasn't physically in possession of it, but the awareness of his physical possession is lacking in the first shot.
The awareness by who? By him?
By the.
So he doesn't know if he's got the gun that he had?
I'm sorry?
The awareness of his physical possession. He's not aware he's in possession of the gun. At this moment, as much as I know, is he had it when he left the police station, that it is in fact his gun, that she didn't have it, and at some point between the time that he left the police station and the time that the victim died, he also had it. So I'm confused about why he would not know he had a gun that was in his waistband. I live in the world, I'm pretty sure that if I got a gun in my waistband, I'm probably going to know it's there.
Yes, you're correct.
A little bit concerned.
And I do see what I failed to explain there. What I meant was that from the moment that the gun was in Ms. Doyle's hands to the defendant's
See, now
hand.
therein lies my problem. Who testified the gun was in Ms. Doyle's hand?
Your Honor, that's the case that we'd like to present.
I get that, but no one said that from the stand. And it is what comes from the stand that I must rely upon in order to either grant or deny your motion. So I know you heard you said it in opening. I was riveted. But I'm not sure that that's going to qualify as evidence that she was in possession of the gun.
We also don't have anyone that stated that she was not in possession of the gun. We can't necessarily prove that she was not.
You don't have to prove anything.
Exactly.
I know. Okay, all right. So at this moment, in order for me to grant your motion, I have to assume that what you're going to eventually have your client testify to or a witness testify to has already happened. I have to make that assumption. Because I can't grant it otherwise. Is that not right? Is that what you're telling me?
In terms of understanding whether or not, like, the physical possession, there's a
Yeah.
voluntary action, but however, the prosecution is charged the defendant with first-degree murder.
Yes, they have.
So the elements of deliberation and intent have also not been shown here from the
Well,
prosecution's case.
I saw something that I thought was pretty effective. It wasn't evidence, but they got the jury hearing that there was a gunshot fired and then five seconds between the first and the second shot. If I would pop out, one thing, but if it's pow, and then at some point I heard maybe even as many as 10 seconds. I don't don't know. Don't you think that that's enough to be able to get the jury to make the call on whether or not there's some premeditation there?
I can
Don't
see
you
how
think
that.
that's enough? Don't you?
I don't believe that that has proven the defendant's guilt beyond a reasonable doubt, no.
You don't think it's enough?
No,
Are you sure?
I'm sure that's not, evidence beyond a reasonable doubt.
Anything else?
That's all you're.
What's your response to her argument?
Your Honor, the standard for a judgment of acquittal at this point in the trial is like most favorable to the state, the non-moving party. And the evidence we have presented has shown intent, and it's substantial enough for the jury to at least hear and consider between the mechanics
Can
of the
you put the gun in his hand?
I'm sorry, Your Honor?
Can you put the gun in his hand at the time of the shooting?
The neuron activation tests that we presented show that the defendant did have the gun in his hand.
You know the one thing that I miss when you talk about the neuron activation test? Is what it means. Someone said neuron activation test. I thought they were talking about something in someone's head. Motor neurons. You know, that's the stuff I don't have any idea what that means. What is a neuron activation test?
Would you like me to explain?
No, not to me, because it gotta come from the staff. Okay, so who put the gun in his hand? I still don't know what that means. I don't know what the neuron activation test is.
We've proven, or we've put witnesses on the stand who have testified that he left that police station with the gun that was armed.
Yeah, that's not the issue. The issue is at the time the gun was fired, are you sure she didn't do the karate move? Take the gun out of his hand?
Yes, Your Honor.
How? Who said that from the stand? I mean, when they talked about the karate move, you never asked the witness that was on the stand whether she saw the karate move. The one who was standing in the window.
She didn't see the crime.
Yeah, I know, but you didn't ask if she saw the karate move. So because you never asked if she saw the karate move, I don't know if she saw a karate move. So, again, how do I know she didn't have the gun? Where's that testimony? I mean,
Your
remember
Honor.
now,
Sorry.
beyond a reasonable doubt, and I'm not sure if she had the gun as opposed to him.
If the testimony of Beth Kelly and of Sergeant Benbrook is considered, it shows that Beth Kelly was standing facing the defendant. But as Sergeant Benbrook testified, the path of the bullet was from east to west, which would have been where the defendant was facing towards the wall and the victim was facing the defendant. So the bullet would have traveled east to west, showing that it is likely to weight, not admissibility, that the defendant shot the gun from east to west. Because if it was indeed in Miss Doyle's hand, it would have likely that the bullet path would have gone west.
You sure the karate move didn't make the gun fire?
Yes, Your Honor.
East to west, twice. Anything else?
No, Your Honor.
Anything else?
We'd also like to add the fact that we have not been shown any fingerprint evidence, whether to prove that Officer Diamond or Ms. Doyle's fingerprints were on the weapon.
Anything else?
That'll be all your.
All right, motion denied. Let's take 5.